Get ready. 3 seconds. 2 seconds. Start. The appellants were convicted under Section 304, Part Roman number 2 IPC and sentenced each of them to suffer RI for 3 years and to pay a fine of rupees 2000 each. In default, to suffer RI for another 6 months with judgment and order dated 7/3/2003, rendered by the learned session judge in sessions case number 160/2000. Aggrieved by and dissatisfied with the same, they have preferred this appeal. The prosecution examined 6 witnesses. The defense examined none. The learned trial court, on completion of the evidence and materials on record, and after hearing the learned counsel for the parties, recorded conviction and sentence as indicated above. Learned counsel for the accused appellants submits that there is no evidence on record that the accused appellants were involved in the death of the victim. The conviction and sentence was awarded only on presumption. The learned trial court has put emphasis on certain facts that immediately after the death, the accused persons, being the husband and father-in-law, did not inform the parents of the deceased and they had fled away from their house. In other words, the trial court relied on the so-called post-crime conduct of the accused persons. According to PP, such alleged post-crime conduct, even if it is taken as true, cannot be ground for conviction of the accused persons. He also submits that the prosecution was unsuccessful in proving its case as per the standard set in the criminal trial, which must be beyond reasonable doubt. I have gone through the records made available at the time of hearing. The investigating officer, during investigation, conducted inquest in presence of some witnesses. According to him, he found no external injury on the dead body. The dead body was sent for postmortem at Civil Hospital. PW6, who conducted the postmortem examination, also could not locate any injury on the dead body of the deceased. He found everything normal. He could not record any opinion on the cause of death of the deceased. The report was collected, but the prosecution did not examine any responsible official from the FSL to prove the same. The aforesaid FSL reports revealed negative test for common poisons. An attempt was made by the prosecution to prove by the evidence of PW1 and 2 that victim was killed by poisoning, but the aforesaid FSL examination is not supporting their case. From the evidence of PW6, it is made clear that he conducted the postmortem examination, being the SDM and HO of the State Civil Hospital, but did not disclose whether he alone conducted the postmortem examination on the dead body or accompanied by some other doctors. In such cases, where the medical officer could not give any opinion, it is necessary on the part of the prosecution to examine the other doctors who were party to the postmortem examination to ascertain at least the tentative cause of death of the deceased. Moreover, the prosecution did not make any attempt to prove FSL report, although the same was collected. The veracity of the report should be tested by examining the officials who conducted the test, and if necessary, it should be referred to other advanced institution to have the expert opinion. In my view, in the interest of justice, the matter should be remanded to learned trial court to examine the doctors of civil hospital, if any, who accompanied PW6 at the time of conducting the postmortem examination on the dead body of the deceased, and have their statements recorded, and also to examine the responsible officer from the forensics science laboratory to prove FSL report. Stop.